Honourable Member Porteous. The delicate mind of a child is impressionistic. Largely pliable and greatly malleable, one is often susceptible to suggestion and coercion. Particularly sensitive to these advances are our Victorian children, whom are essentially abandoned and expected to navigate the fervently complicated judicial system armed with nothing but their naivety. My words are derived from my personal encounters in regards to contradicting evidence. My cross-examination was prolonged and extended the entirety of 10 business days. I am a woman who has an extensive and expansive vocabulary. However, my experiences rendered me incapable of verbalizing the severity of the situation at hand. The reality is children are not able to reiterate the gravity nor nature of the questions they have been proposed. Furthermore, given the deprivation of education and information regarding one's right in court, children are ultimately left clueless and have no ability to decipher what is inappropriate. This lack of knowledge has disastrous effects, leading to many engaging in conversations that may be harassing, intimidating, confusing, and misleading. The abuse children suffer is compounded by the neglect perpetrated by the legal system itself. Psychologist Elizabeth Loftus, particularly concerned with how subsequent information can impact the evidence supplied by a witness, found that the memory for an event, emphatically one deemed traumatic, is exceptionally susceptible to alteration as a result of misleading and or suggestive propositions. Thus, children who are uneducated nor knowledgeable of the system prior to their integration may result in the eyewitness testimony being considered unreliable and influenced, given they are unable to prevent the integrity nor retain the authenticity of their initial memory. For many, it is as if they are to function under duress. The bill that reads Reform of Youth Court Services Bill 2018 proposes that an educational entity be formed and implemented in schools in order to inform children of their rights within the legal system, the roles of the legal bodies, including counsellors and other support persons, and the proceedings that are found within the court system. Concurrently, this implementation shall encourage Victorian youth to seek legal assistance when applicable, and shall influence children to refrain from engaging in potentially traumatising and inappropriate conversations. Yes. It is indisputable our legal system is failing our children. It is accepted within the psychological field that the rational section of the brain is not fully developed until one reaches the age of 25. Adults are reliant upon their prefrontal cortex. This aspect of the brain is predominantly associated with rational and calculated decision-making. Comparatively, the mind of a child is a device that is contrastingly distinguishable. Children's brains are more so reliant on the region that is the amygdala, a region that parallels emotional responses. I put this proposition to the members of this chamber. If it is known that the mind of a child is, in comparison to the mind of an adult, relies on varying mechanisms and greatly lacks in the ability to produce methodical conclusions, why do we essentially expose them to such potent content? It takes a village to raise a child, yet one singular match has the capability to devastate a forest. If we do not take the appropriate prevention and shield our children from the malignant and unforgiving poison that resides within court proceedings, then we are all neglecting the fundamental duty of care we generationally owe our youth. We propose that the freedom be allocated to the children, allowing them the option to compromise the typically formal attire in order to create a significantly more so aesthetically pleasing atmosphere. This implication shall alleviate the feelings of alienation and shall strengthen the child's comfort and feelings of security, given they are returned an expressive aspect of their identity. Furthermore, we suggest youth are given ample and undefined range of recesses. This implication is invaluable. In regards to my experiences, my breaks were incredibly limited given their necessity. I was indescribably fearful my case would be forfeited when the impact from cross-examination had on me was evaluated. Resultantly, I forced myself to continue until it was classified incapable of continuation. This is the reality. We are alone, isolated, and often impacted beyond recognition. However, today we have a choice. You hold the power. Stand with me. Be vocal in your acknowledgement. For the little girl I met at the protected witness building, the one whose face sported streaming tears, and the hundreds of illustrations that adorn the wall symbolizing a child who has suffered similarly to I have.
Well said.
For all the children to come, and those who are too fearful to approach the assistance they require.
Well said.
We are defined by our actions. It is through the repercussions and ramifications that we are remembered. Today signifies a change. Jesus. Join me in this pivotal moment. Let us, Jesus, join me in this pivotal moment. Let us safeguard the future of our youth.
Jesus. Honourable member.